so let's get started. We're going to talk about mastering difficult client moments. And in this particular session, we're going to talk about things like trusts and powers of attorney and various other things. So let's start with a little story. I had a property listed that was owned by a trust. The homeowner had died, and there were two siblings who happened to be estranged, and they just in a very bad way. They didn't like each other at all. One of them signed a listing contract with me and assured me that he had the power to sign this on his own, that it didn't require anyone else's signature as a signatory to the trust. And I thought that was a little unusual, particularly when there were only two siblings involved. So I checked with the other sibling, and she advised me, no, that's not true, that they both had to sign the any documents as it related to the sale of the property. And so I asked both of them for the certificate of trust existence and authority, and they indicated that, and that document clearly indicated that both trustees' signatures must be were required on every single document. So if we had gone down that road with assuming or accepting the first sibling's representation that he could sign completely alone, we would have found ourselves in a mess. So, Luis, what you got?
Yeah.
Anything?
It's almost similar. I had two siblings there whose mom passed, and at the beginning they were it was tough to get them on the same page, and I requested to meet them at the house, and just I had a little chat. I told them first being sensitive what they go, because they go through a lot of emotions. There are a lot of memories and childhood and all the stuff in the house. They grew up on it. And then just, making that pledge. My goal is to get you the most amount of money and make the sale as smooth as possible for both of you. And I'm asking both of you, will you trust me with this? And once I put them together in the same room, it became easier after. Then I would communicate separately, of course, time to time, but it was smoother than I expected, telling the truth. But there are a lot of what I noticed. There are a lot of emotions involved during the process.
Mhm.
Because
So
they go, yeah.
here's a question. When should you ask for the certificate of trust?
Immediately.
Immediately.
Oh, yeah, very good. I got it actually before my listing presentation. I asked for an email to copy it to me.
Yeah.
Yeah. Ask for it immediately. And then there's also a timetable associated with that as well. What happens a lot of times is a trust is written. Like I had a trust written, 15 years ago. And we've updated the trust a few times along the way, sold houses, kids got older, identified a different person in our trust to act on our behalf because our children were younger. But when you have a certificate of trust, a lot of times, let's just say you had your trust written 10 years ago. The certificate of trust would have been written and put into your trust binder at that time. Had no changes ever happened, the certificate of trust would have been dated 10 years ago. But to sell real estate, there's a particular date that the title company is going to be looking for on that certificate. So, Don, if somebody got the certificate of trust from from the trustees who are acting on behalf of the persons that are deceased or unable to make their own decisions, what should they do if the date on the trust is really old?
Well, I would have it reviewed by the title company. I'm not familiar with that, Tracy. I've not run into that before,
Oh.
where a trust certificate or the terms of the trust expired without something else happening. So
Yep.
I've simply not run into it.
Good. Okay, so here's the deal. So if you get a certificate of trust from the trustees, and they're the people that you're in front of, the certificate of the trust has to be dated within 2 years of the time a transfer or anything will change with the property. So they'll need to go back to an attorney have the attorney review all the terms of the trust and certify that there have been no changes since the trust was signed. And if there have been no changes, they'll just write a new certificate and they'll have it dated today. And now that will be good for a 2-year period. And the title company won't touch it without it being within 2 years of the time the last certificate was signed.
That's great information. Thanks for sharing.
Yeah.
Yeah.
And that's why it's good to really do the pre-title search like ASAP, because you never know what else could be there that people on the trust might not even be aware of.
Yeah.
Yeah.
And I would just say this too. First of all, Star Title can help you with that. They have an attorney on staff. I think they charge $100 or $200 to have that trust binder reviewed and a new certificate issued. But also, you may have people like myself where we have not recorded our trust. So our attorney recommended that we keep the trust. It's signed, it's dated, it's fully executed, but not recordable until my death or at a time that I can't make decisions for myself where my executor will have to step in. So ask a lot of questions. It's important to talk to the people that you have the opportunity to be in front of to find out all the different pieces and parts. Just because you can't see a trust doesn't mean one is not in existence.
So the document I'm going to repeat again is the Certificate of Trust Existence and Authority. That is the legal name for the document that you want. The moment that you hear the word trust, that's when you ask for it. I want to see your Certificate of Trust Existence and Authority, because that's going to spell out, first of all, as Tracy mentioned, the effectiveness, the effective date of it, but it also points out who is going to be authorized to sign on behalf of the trust, whether it's one individual or 2 or 3, whatever the case might be.
Hey Don, does everybody know about the word record? We keep saying the trust needs to be recorded. Does everybody know what that means?
Well, explain it, Doug.
No, well, because again, you get into a lot of conversations about that. I'm not an attorney, guys, but I do have an awful lot of people saying, well, is that trust recorded? And again, I'm going to lean heavily on what Tracy just said with regards to the title company. I mean, I take a lot of direction from our gals at Star Title because I don't know the answer to those questions. But doggone it, I'm going to make sure I'm asking those questions up front. I'm going to be getting as much information as I possibly can up front. So literally, I know what I'm getting into. So that word just keeps coming up, that word recordable. And I'm saying to myself, well, what does that really mean? And if I get a lot of information on someone's trust, someone's going to give me direction as to what happens next, right?
Yeah.
So
Well, I think it's having it recorded is important because if it happens that they're for whatever reason, the deceased or the person who is no longer capable of working in making decisions for the trust, if they become incapacitated, if it's recorded, they can go back and find it. It doesn't get lost. If
Yeah.
it's not recorded, and Tracy, correct me if I'm wrong, but if it's not recorded, then somebody's going to have to find it before it can be acted upon, right?
Right. It's still enforceable. It just once you have knowledge that it's there, then it gets recorded.
There
But
you go.
the date it was fully executed was, at the time, the individual signed their trust, but it just has to be recorded after the death.
Yeah. I want to move on to scams because we're seeing a lot of scams, particularly with people who are either under a conservatorship or guardianship or deceased. So let's pretend you're contacted by somebody who wants to sell the home of a deceased person. What do you do first? Louise, any thoughts?
First, identify the identity of this person. Verify, if this person who's contacting you is the right person, and check again immediately if I see any red flags. A lot of scams are requesting these days, like Zoom or anything that I can smell. It's a scam. I do ask extra questions, and of course, it could be a legit person. I do very sensitively ask, please, forgive me if it's occurring to you, I'm questioning you, but there are a lot of scams going on, and I have to protect everybody's interest.
Yeah.
And
First thing, and I'm going to say, if the phrase I have heard, and you, I'm not calling you out exactly here, Luis, but I'm calling out a phrase that I hear a lot, which is if there are any red flags. And I would caution that agents today should make it a common practice, a consistent common practice, that every single time they prepare for a listing meeting, they need to have identified who the owner is prior to that. They should check the tax records. They should run a pre-listing title search. They should identify whether or not that co-ownership is with a spouse or a life partner, a child, sibling, and what the nature of the ownership is, how the title is held, whether it's joint right of survivorship or tenancy in common. All of those kinds of things should be identified before you go out on a listing appointment.
And I check their phone number on a forewarn if it's a match with the name they're giving us. So we do want to do extra investigation in a sense on background. So for sure.
So, how many of you have run into a Ladybird deed? Anyone? Does anyone know what a Ladybird deed is? Blake, I'm going to call on you. You're muted.
Sorry, yep. So I just went through this here in the last few years personally because my father passed away, and the minute he did that, his property was titled right over to me because of that later Ladybird deed. That's something that must have been set up, or that is set up in the trust or what have you ahead of time, to transfer title of ownership. And it could be a long time. As a matter of fact, that had been set up for 50 years. So that I know of. So
it's my understanding that Ladybird deeds can avoid probate, but I caution that whenever you get into this sort of thing, make sure your client is working with a qualified elder law attorney. We cannot give legal advice, and this is an area which is very complex. A Ladybird deed can be granted by the owner to an additional owner. For example, in Blake's case, what a lot of people don't understand is that the Ladybird deed is revocable. It doesn't necessarily carry with the property. Sometimes parents will say, well, I'm going to go in for surgery and I want you to be on my deed so that if anything happens, the property will transfer immediately to you. And thankfully, the surgery goes well, and they come out and they say, that's all great, we're all good. And oh, by the way, I've just revoked your ownership that I granted to you on Ladybird deed. Does everyone know that? Does everyone understand that a Ladybird deed is a qualified life estate? That's the nature of what a Ladybird deed is. So
yeah, different than adding somebody on title jointly together.
And what's the risk of adding somebody on title? Let's say, mom's getting older, and I had this one just recently, and so she put her 3 children on the deed before she passed. And so ultimately, it was their property afterwards, and it was relatively smooth, but there's risk in that. Tracy, what's the risk?
Fighting. usually fighting. And the Ladybird, I mean, the nice part about the Ladybird, I think people that probably typically do Ladybirds they don't have a lot in their estate. And so it's usually their home is the largest piece of their estate. So when you do a Ladybird deed, you're essentially just naming a beneficiary. So in the event of your death, your kids don't have to go to probate. And of course, we're not attorneys. But your kids don't have to go to probate. The property passes from you directly to those that are stated in your Ladybird deed. The thing to be careful of, I would say, in the Ladybird situation is, let's just say it was me and I had a home that passed to my son. And when he received the property, it was eventually it's going to go non-homestead. So you have to pay attention to those things. Then when I owned it, I occupied it, the two tests. Number one, you own it. Number two, you occupy it to get homestead. But once it went to my son, those taxes are going to uncap. So somehow we need to go in and let the community know either my son is now going to occupy it as his homestead, or we at least need to let them know that we're related so that the taxes don't uncap totally. They might uncap to non-homestead if it doesn't become his primary residence, but it won't uncap to today's tax value because we are related.
So going back to the question of putting the siblings on the on mom's deed, as you say, one of the risks is that now we have to have 4 signatures on any document, whether it's the sale or the transfer of the property in any way, and they all get to make a decision about how the property is maintained and so on. But another risk in this situation is that what happens if one of those siblings gets gets drunk and kills someone in a car accident? Now, one of those assets is 1/4, for example, of that property, right? So this is why we really, really encourage our agents to make sure that your clients are getting good advice from a good estate lawyer, elder care lawyer, and all of those things. It's really important they get good guidance from an attorney. I want to move on to talking about probate court. That's one we get a lot of issues with. Is there a will? And does that what happens when there's a will, but it has not a personal representative has not been assigned yet to the estate? What happens? Tracy, you're smiling. Come on, give me an answer.
The family's going to have to go to probate court, and a personal representative will have to be identified by the courts. Typically, I've worked with people before in advance and listed their properties and made it known to the public that the property is in the midst of probate, but it can't close until you get that piece of paper where the personal representative has been identified by the probate court.
Yeah, and it doesn't matter if the will identifies an executor, it still has to go to probate court.
Yep.
So what documents are necessary when a potential personal representative takes the issue to probate court?
I'll say, so for me, what I've done is gotten a copy of the death certificate, provided any of the, when I did it before, we didn't have a will. So literally it was just the children identified themselves, as the, what's the word I'm looking for? The heirs to the person that had been deceased. I've done it for a wife before, so they were married, so that was easy. We had the marriage certificate and the death certificate, and you need to get a probate attorney. I don't know anyone that's done probate on their own in the absence of an attorney. It probably could be done. I have not done that before, but really, you just really follow the wishes, whatever the attorney is. He's the one that directs the path. They're going to help you get through it. It usually takes 30 days, maybe a little bit less, depending on what kind of property the person owns, etc. But yeah, you need a good an attorney.
I'm going to try to address a few questions here in chat. And Melissa, you asked the question, an agent may engage legal service via 5-star at an hourly rate. Actually, I think what Tracy was saying, and Tracy, correct me if I'm wrong, but this only pertains to the certificate of trust existence and authority and getting it updated, and that is a star title attorney who is offering that service. Is that correct, Tracy?
That is correct. Yep. 5-star does not provide any legal services on a per hour basis. I don't know who's not muted, but someone's not muted.
And we're gonna
I can tell who it is. It's Patty Cyberski.
Yes.
Hi, Patty. You're not muted. There you go. Um, so anyway, so yeah, so we don't provide any legal advice at all at Five Star Real Estate nor Star Title, but we can engage our attorney, an attorney through with the help of Star Title to help get an updated certificate of trust if needed.
Listing an investment property purchased as a rental, owner did not know the deed was no longer in their name. Help me understand that one.
Don?
Yep.
Okay. So the seller came to me and said, "I'd like to list this investment property." And they didn't have any information about the deed. I did a basic search and found that the deed was no longer in their name. They did not know that. And they'd purchased the property as a rental property for their family, but really never collected rent, just let their family live there. And apparently the family occupant was paying the rent. The property was in a trust and no one was paying any attention. And the property went to foreclosure because of, this is a really odd thing, because the property was purchased in cash by the trust, by the rightful owner's trust. It was a mess. So there was listen to this, there were 2 HOA liens on the property, which sent the property to foreclosure. I learned all of this just digging into the county records. And I had to go to the potential client that wanted to list with me and say, "I can't help you. You need to talk to an attorney. Did you know that your property is no longer in your name?" No, I did not know that.
Yeah. I'd like to know more about that. That sounds like a mess, as you describe it.
Mhm.
How did somebody manage to hold on to a property for 9 years that went to foreclosure
Correct.
9 years ago? That's, I'm curious. I'd like to know more, but maybe you can send an email and we'll try to dig into that because that would make a great teaching lesson with all of the details.
Well, I think what we have here are many hundreds of examples of fraud, and that the family member and a third party were able to, there's so many things going on here. It's fraud, it's elder abuse, it's completely just
To know
it's
more.
just terrible and to have to be the messenger of that, not being, I didn't explain anything. I just, because I couldn't
Yeah. Let's
judge, as Luigi would say. I just had to acknowledge this is what I learned, and I suggest you hire an attorney, and that was it. And
yeah.
thank goodness for Luigi saying, "You don't know what's going on, have them talk to an attorney."
Yeah, that's great advice. I'm going to move on here and talk about powers of attorney. Uh, do you ever get a call and the potential seller says, "Well, I have power of attorney"? Who's gotten that call? I think most of us have. Here's the interesting thing. When they start to talk about powers of attorney, sometimes it's not a durable power of attorney. And even a durable power of attorney does not necessarily grant this person the right to sell the property. So it's important that you get the document, whatever document they're talking about, you want to be able to look at it and read it over and say, does this in fact grant this person the right to sell this property? And hey, guess what? Talking about fraud, we've actually seen documents, powers of attorney, that have been signed and notarized by people fraudulently. Imagine that. There's a lot of it going on right now. You have to have your awareness at high level right now because it's happening every single day. But a lot of people believe that their power of attorney is still in force, even though mom or dad has become incapacitated and unable to make decisions. And it's not. If they are deceased or if they are incapable, that power of attorney is no longer in force. unless it is specified in a durable power of attorney that they do have the right to do that. But again, that's not our decision to make. That's a decision for the title company or an attorney to make, and that's where you should send them. Does that make some sense? Okay, let's talk a little bit about guardianship versus conservatorship. Guardianship is very simply when a person is incapacitated and they go to court and someone gets guardianship over them. And that's basically to keep the bills paid, to make sure the lights stay on, the electricity stays on, or the gas and furnace stay on, and all of those kinds of things to maintain that individual's health and well-being. However, a guardianship is more strict than that. It is more encompassing. A conservatorship takes over their dealings completely. That person is no longer capable of filling out or required to fill out a seller's disclosure form, for example. Conservatorships are really, really important when we suspect that a person may have dementia, and we need to be on high alert when a potential client is saying something that doesn't seem to quite fit. Tracy, I think you ran into one fairly recently, did you not? Maybe it was, I'm sorry, maybe it was somebody else.
Definitely in the past. I haven't had anything real recent, but definitely have in the past. But yeah, you have to follow the documents that are in front of you. I think, as you said, Don, the best thing that you can do is get the documents to the title company as quick as you can so that they can tell us how to direct our client.
We had one a couple of years ago that I was involved in, and it was interesting because there was a conservatorship in place, but it was it was not being enforced. And so this person who had dementia, clearly had dementia, continued to make decisions which were not in their own best interest. So it's really important. And this client was saying things that didn't add up, that should have caused our agent to question it and go, wait a minute, I need to talk with someone. The catch-22 here is that we are not qualified to make decisions about whether someone has dementia. We're not psychologists or psychiatrists. And so, therefore, what is our responsibility when we find someone who's not making sense? And how do we stop that process? Anyone? Luis?
It's kind of tricky again. I would get attorneys involved and direct them to proper channels, maybe to do a medical evaluation or whatever it's needed. But it's like Tracy was saying, between the title and an attorney, you got to go. If they don't have any family members or anything, if I would see some kind of red flags in their capabilities to make decision, I would just do whatever I can to send that alert, that red flag. And at least we're protected that we attempted, or maybe send even an email, to that client, making that request, making that suggestion.
And sometimes there are family members involved. In this particular case, the conservatorship was granted to this seller's sister. We happened to have her information, and we were able to contact her and have some conversation about the ability of the seller to make decisions. And that kind of led us down the path of trying to get this resolved. So that covers a pretty broad bit of ground there. Jill just asked a question, at what point do you call the family, and would that be overstepping, especially if the client wouldn't? It just got deleted there. Wouldn't want you to contact the family. Well, that's a really good question, Jill. And it is a very delicate question. I mean, but again, we have to be very careful from a legal standpoint that we are protecting the client's interests, even if they don't think we're doing that. If we have suspicions, as Louis says, if we have red flags that say that this client is not capable of making decisions, then we do have some responsibility. How do you identify that? I'm not sure. I would say to you, if you have those questions and you're faced with this situation, call broker support. If necessary, we'll get our attorneys involved to identify what the best path forward is. Does that make sense?
Yeah, and I would say there's also several places where this kind of oversight takes place. One is at our level, where when we sniff something out and it doesn't seem right, like, ugh, and we can't get others to listen. The other places, when you get to the closing table, I have been at a closing table before where the title person just said, we're stopping this now, because the daughter was directing the mother, sign here, sign there. And the title person finally realized, I don't actually think the person that's here with the pen in their hand is the one making the decision. So know that our title friends are also working in the best interest of the clients that they get in front of, and they also have a duty to protect the public.
Yeah. You just brought up a really excellent point, Tracy, because there's a legal concept called undue influence. And if someone in that homeowner's sphere has undue influence, for example, mom lives with daughter and the other four siblings live out of state or don't interact with mom as much as the daughter with whom she lives, there could be a challenge against the will or even the trust, stating that daughter with whom she lives has exercised undue influence over mom. And that's a legitimate challenge to either a trust or a durable power of attorney or a will. Sorry, just left my mind there for a second. So a lot of things to consider, and I just caution everyone that when you are faced with one of these situations, bring it to our attention because we'll get you whatever help you need to make sure that we're operating legally. Does that make sense? Any questions?
No. Thanks, Don. Thanks, Luigi. Doug, he left. Oh, there he is right there.
All right.
No other questions in the chat?
Hey, thank you all for joining, and